case briefs, and so much more. LSData's got what you're looking for.
In a 2003 gender discrimination case, Zubulake v. UBS Warburg LLC, the United States District Court for the Southern District of New York, considered whether the production of inaccessible electronic data is worth the cost. The court took into account factors such as the specificity of the request and the availability of the information from other sources. It was determined that cost-sharing may be appropriate, but the producing party is solely responsible for the production of data once it is accessible. The lawsuit was initiated by Zubulake, who accused UBS of gender discrimination. During the proceedings, the court ordered UBS to restore and produce certain emails from backup tapes. UBS argued that Zubulake should share in the cost of production. However, the court ruled that UBS must bear the majority of the expense, as Zubulake claimed that 68 of the emails were highly relevant. Zubulake moved for an order compelling UBS to produce all remaining backup emails at their expense. The court ruled that while Zubulake must share in the cost of restoration, UBS would bear the majority of that expense. UBS was also held responsible for any costs incurred in reviewing the restored documents for privilege. The core of the dispute centered on which party should pay for the costs incurred in restoring and producing these backup tapes. The court ultimately allocated the costs of restoring backup tapes between UBS and Zubulake, with UBS bearing all other expenses. Although UBS could have potentially shifted costs by offering the plaintiff under Rule 68, cost shifting was deemed appropriate only for inaccessible data. The producing party controlled the review protocol for electronic data, and UBS was held primarily responsible for the costs involved in the case.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.